Local camping rules for the homeless could be headed for a major change when the U.S. Supreme Court makes a ruling. Good afternoon. The case involves Grants Pass, but the decision could impact Central Oregon and communities across the country. Isabella Warren explains.
Local homeless advocates are weighing in on Monday's hearing of the landmark Grants Pass homeless case. The city wants to ban sleeping in public.
I'm sympathetic to the fact that we would like to have our public rights of way. We'd like to have a clean, beautiful city. And currently, by pursuing this criminalization route or continual displacement, it in fact worsens the crisis that we're all dealing with, seeing evidence of.
Eric Garrity with the Bend Equity Project says more affordable housing locally needs to be the focus if the Supreme Court rules in favor of Grants Pass.
Where do we put them if every city, every village, every town lacks compassion and passes a law identical to this? Where are they supposed to sleep?
Grants Pass v. Johnson challenges the city's ability to enforce camping codes in public areas through ticketing. The cost of a citation is $295 and increases to $500 if not paid. In 2020, the Ninth U.S. Circuit Court of Appeals ruled Grants Pass was in violation of the Eighth Amendment, citing they had no public shelters for the homeless to go. The Supreme Court will decide whether local governments can issue citations to people who sleep in public areas, impacting how cities handle their homeless populations. If the Supreme Court decides city governments cannot enforce laws, the Deschutes County District Attorney says there will be a complete overhaul for law enforcement.
Are they able to, for example, issue a citation to somebody who's been camping in a place for a long time, or spreading trash, or making the place unhealthy due to waste that is left at a location? Are they able to take any enforcement action at all?
The homelessness argument has long been left up to states and local governments to decide, but this ruling could change that.
We usually think about whether state law, local law already achieves those purposes so that the federal courts aren't micromanaging homeless policy.
What the solution is up for debate, but there are problems. And this case will create a blanket rule, hopefully, for the United States, so that we can at least have uniformity and a clear understanding of what the limits are for enforcement of the laws that the legislature passes.
Deschutes County has rules against camping on county-owned land. Camps are allowed in a spot for 24 hours. A 72-hour notice has to be given before the area is cleared. Unlike Grants Pass, in general, no fines are given for violations. But advocates say the Supreme Court case is creating uneasiness.
It's one concern on a laundry list of concerns. The message that I've been trying to communicate to folks is that regardless of the outcome of the court case, there's going to be advocates that are continuing to fight for them, to look out for them.
The justices will now deliberate. They're expected to make a decision in late June, so no changes will happen here locally until we get a decision.
Any indication which way the Supreme Court may lean in this one?
It's way too early, and they were very divided on Monday.
All right. Thank you, Isabella.